On March 30, 1981, John Hinckley Jr. shot President Ronald Reagan and 3 others outside a Washington hotel. He was arrested at the scene with the gun in his hand. The evidence of what he did was not in dispute. 3 years of psychiatric evaluation and legal proceedings culminated in a jury verdict that shocked the country, not guilty by reason of insanity. The public outrage was immediate and bipartisan. The insanity defense traces to England in 1843. Daniel M. Naden killed the secretary of the British Prime Minister, while suffering from paranoid delusions. The American federal standard in 1981 was broader. Under the Model Penal Code test, a defendant was not responsible if they lacked substantial capacity to appreciate wrongfulness due to mental disease. Hinckley's attorneys argued he suffered from erotomania and schizophrenia. The 1984 Reform Act returned to the stricter M. Naden standard and shifted the burden of proof. Previously, the government had to prove sanity beyond reasonable doubt. After 1984, the defendant must prove insanity by clear and convincing evidence. The practical effect was dramatic. The insanity defense is now raised in less than 1% of felony cases and succeeds in approximately 1/4 of those attempts. The public perception that defendants routinely escape punishment through insanity is statistically false. Not guilty by reason of insanity does not mean walking free. Hinckley was not released. He was committed to St. Elizabeth's Psychiatric Hospital in Washington, where he remained for over 30 years. Hinckley was granted conditional releases gradually beginning in 2016. His unconditional release came in June 2022, 41 years after the shooting. Not guilty by reason of insanity kept him institutionalized longer than a conviction likely would have.